afternoon, everyone. Thank you so much for joining us for our last 2-hour law credit that we will be giving before the biennium is ending. A couple housekeeping items. As you saw on the commercials prior to this webinar beginning, we have very strict rules on how to get CEU credit for this webinar and any webinars that we provide. You need to register on your portal, and you need to do that prior to 1 o'clock on webinar day. And then once you click on the link, you will need to register again. So it's a two-step process. We really need both of these steps to be done in order for you to receive your credit. Also, you need to be on the webinar for the entire time. If for some reason you get cut off or it calls, the call drops, please get right back on. And if you can't, contact us immediately. You can do that by calling the office at 1-800-291-2629 or emailing myself, Kelly at NYSFDA.org, and we will help you get back on. This is a very big webinar for us, so we're asking that you give us about 10 business days in order to get the credit recorded to your portal, and you will get something in the mail letting you know you've received credit. At this time, I'd like to welcome our presenter. Everyone knows Tom Fuller, but Tom is formerly of Ithaca. He graduated from Simmons School of Mortuary Science in 1983. He was an instructor and dean of students for Simmons as well for 15 years. He was technical director and later chairman of the Central New York Eye Bank and adjunct instructor at SUNY Canton. He's published several articles for the Director magazine and spoke at several venues around the state for continuing education and has consulted on several projects, including founding of the Green Springs Natural Cemetery in Newfield and the National Geographic Channel's The Mummy Roadshow. He holds a bachelor's degree from Mount Vernon Nazarene University and a master's of science degree from the New School for Social Research in New York. And he's been the director of the Bureau since 2016. Welcome, Tom.
Good morning, or good afternoon, rather. I was on mute and I forgot to unmute for a second. Yeah, thank you for having me. And if you were at the convention last year and heard this, you can't actually get credit for it again. It's the same presentation I did at the convention. On that note, unfortunately, I won't be able to be at the convention this year. And so I'll miss seeing a lot of your faces, but I know that Kelly and Mike will put together a good program, and I'll cover that. I have a couple of my own housekeeping items to discuss before we get into the presentation. You should have received your registration renewal for your pocket card. We have a very small staff. We're getting tons of mail coming in. We had one gentleman has called 3 times saying he didn't get his application yet. If you don't get your application by the end of this month, certainly reach out to us and we'll put you on the list for duplicate. But we did have that gentleman that called 3 times. He called again yesterday and said, oh, it just came today. So they're still going out. We've had almost 100 that have been returned by the post office as undeliverable. Because apparently there's a lot of funeral directors that will move and don't follow the regulation that requires them to change their address with the department within 10 days. So those ones go to the end of the line, unfortunately. So we were getting a slew of address change forms coming in. Hopefully those are ones that were forwarded to the recipient, and now they're getting their address corrected so that their pocket card doesn't get returned. So we're still working on it. It's a work in progress. We ask that the applications come in by June 1st to give us time to turn around and print them so that you actually have a pocket card by July 1st. With that said, if you want to switch your registration to inactive, just simply check that box and close the check, and we'll go from there. If you're not working in the business, but you want to keep the license active, don't check inactive. That happened last biennium and biennium before that, where somebody would want to keep their license active, but they would check off inactive on the form, which means that you're going to get a card with no registration number on it. That's a subcategory that was kind of a product of the continuing education law when that came out 20 some years ago, I guess now. So if you want to keep an active license, even if you're not working full time, make sure you check the active box on the application. And any corrections of your email or anything like that, make sure that's current on the back of the form. And our data input people, or person, I should say, is double checking those as she's putting them on the database. If you do need to change your address with us, there's a form on our website to do that. Database changes require a signature. Believe it or not, we've had people in the past try to change other people's addresses. So that's why we require a signature on those things. So with that, we'll talk about our topic today is misconduct in the business and practice of funeral directing. And my slides are not working. There we go. I guess you got to click the mouse once first. So we're going to talk about misconduct. There's two things that we're going to talk about, and it's going to be the laws and the regulations. So the first statement we're making here is misconduct is not just simple non-compliance. It can be, but there's a lot more that's entailed with that. And the whole concept of misconduct comes out of the actual public health law, and then it's further refined and defined by the regulations. So misconduct does carry potential for serious consequences. Most of the time, the complaints we get and the investigations we do are for fairly minor things, and are usually treated pretty quickly. But I gave the same presentation last November in Syracuse, and I mentioned to the group, it was the week before Thanksgiving, and said there's two funeral directors, or rather former funeral directors, that won't be coming home for Thanksgiving. They're having their Thanksgiving dinner on a metal tray in a state prison. One from each end of the state. Both of them ended up in jail. We heard that one of them just got out in December. But the way they ended up in prison started out with a small complaint about misconduct. And in the course of addressing those complaints, one item led to another item, more information came to be, and eventually we involved law enforcement. Both of them were had their licenses revoked. Both of them lost their businesses. Their firms are closed, and again, they both went to jail. It's usually that's fortunately extremely rare. So most of the misconduct that we're going to talk about is pretty straightforward. If you think that you're doing something that's not compliant, and it could be something as simple as your GPL, we're always here to help you. I think there's been in the past some hesitation to call the Bureau when you have a question. For example, one of the most common non-compliant issues we see paperwork-wise is the itemization form. The itemization form in New York has a very specific layout and format and order. And there's a couple of national companies that produce itemization forms that they market to funeral homes, and those are not compliant with New York State. I know of at least 2 funeral homes that have been using them, and once that's pointed out, you need to change that. So if you're not sure you're in compliance, go ahead and give us a call, send us a copy, whatever you're working on, if it is a paperwork issue kind of thing, and we'll let you know if you're compliant. We're not going to ask for the last 100 calls you did and then fine you for each one that used the wrong form. That's not what we do. We're here to help you be compliant. If you are given an order to correct and you don't obey it and you ignore it, then we have an option of going forward with a charge of misconduct. So with that, we're going to go ahead and talk about what misconduct is and where it originates in the public health law. So public health law is legislation that's passed by the state legislature, signed into law by the governor, and that becomes actual law. We can't change it, we can't suspend it, we can't misinterpret it or reinterpret it. It's law. We can't do anything about that. Now, 3450 talks about revocation of licenses. Okay. But it doesn't really talk about the definition of misconduct. So what we have both the legislation, Public Health Law 3450, And we also have the regulations at 77.12, which is going to be the bulk of this discussion today. The regulations do the clarification and explain what exactly misconduct is. So we're going to look at the law in the next few slides, and then we'll move directly into the regulations. So 3450 deals with suspension and revocation of licenses. And quoting from that, it says the commissioner may revoke or suspend any license of a funeral director, or may reprimand or otherwise discipline such licensee upon proof that such licensee, then drops down to a whole list of items. The sixth one is letter F, and that's our topic today, has committed acts of misconduct in the conduct of the business or practice of funeral directing, undertaking, or embalming, or in the business of such funeral firm. So this is letter F. There's obviously 5 more ahead of that and a few that follow it. I think there's 15 altogether in that list. And it doesn't define misconduct in the actual legislation. It does rely on the regulations to go further with that and explain specific items that are misconduct. So that's going to be the bulk of our discussion today. So there's 15 different items. It says we're not going to discuss the other 14, but actually I do want to mention those quickly. Letter F is what we're going to be dealing with because that drops into 10 NYS 77.12, which simply means New York Code Rules and Regulations. And that's where we're going to be discussing it. But just got to put the glasses on quickly. In this list that I was mentioning here under 3450, paragraph A is a kind of a catch-all. It says, has violated any of the provisions of this article, the sanitary code, the rules and regulations of the commissioner, or any statute, code, rule, or regulation relating to funeral directing, embalming, or vital statistics. So if there is a cause to bring somebody forward on charges, that one's always thrown in there. It's a catch-all. It just says you broke the law, or you broke the code, or you broke the regulation. And so it's a kind of an add-on. So when we do a referral for enforcement, that always gets thrown in there under the public health law. And the reason I bring that up is because you're going to see something very similar to that under 77.12 under misconduct. So I should give you a little background about how the process works. On something really minor, like you're using the wrong form, and we learn that sometimes when you hire a resident or you change managers or something, we'll request copies of your documents, and we'll examine them and make sure they're compliant. And if they're not, 9 times out of 10, it's a simple phone call. If it's a bigger issue, we might send you a document that's called an order to correct. And this is not a charge of misconduct. It's just saying, hey, we noticed this is not compliant. Please fix it. Send us documentation that you've done that. And then we have you on notice for that. Something more severe, it would be something called a stipulation and order could be sent to you. And that's generally a legal document that comes from our Division of Legal Affairs. And it states what the violation was and what the suggested penalty is. And you can either sign it and send it back, or you can request a hearing. So for example, if you fail to register your funeral home, again, in the odd years, you do the re-registration, the biennium for the funeral home itself. And if you neglect to do that, usually by the end of October, we put together a list of those that are not registered, and we send them a letter stating that they're in violation. And once they are registered, we count up the number of days that they were unregistered, and we put it on a spreadsheet, and we send it over to DLA, Division of Legal Affairs, and they put together these orders and stipulations. Now, what that means is under the public health law, for every day your firm wasn't registered, or any day there's any violation, you could be charged $1,000 a day for each day of the violation. So since the department isn't looking to bankrupt anybody, a lot of these come out, they're 62 days or 68 days late. We're not going to demand $68,000 from you. So usually this order stipulation, think of it as sort of a plea bargain. We send you the order and stipulation, rather the Division of Legal Affairs will send you the order and stipulation. It says, here's what you did, here's why we're doing this. We're going to offer a settlement of maybe $1,000 instead of the $64,000 that you could be paying. And it basically, you sign that, send it back, it goes before the commissioner. The commissioner can reject it. It's rare, but that would be the normal process. And once the commissioner signed off on it, then you pay the fine and you move forward. In a more severe case, I'll give you an example. We had an individual, or a firm, I should say, that was offered a stipulation for a violation in which they left a body in a morgue for multiple weeks. They were offered a stipulation, in other words, a settlement. They declined that and went to a hearing, and you're entitled to a hearing before revocation. And they went to a hearing before an administrative law judge. They lost the hearing. They were allowed under article, I can't remember the name of the article. I think it's like Article 78. They appealed the hearing or the findings of the administrative law judge. So before it even went before the commissioner, they did an appeal in the regular courts, lost that one too. Ultimately, because they did not accept the first stipulation, on top of all the multiple legal fees they had for the months that this dragged on, they ended up, the court in the state of New York determined that they were culpable, and they ended up paying the fine of, I believe it was like $28,000. So there is a process to that, but normally we're going to try to keep this. 99% of these things don't ever go that far, and it's a good thing. I think most of the field directors in New York are rather good at keeping compliant and checking about things if they're not certain. So the 3450 then relies on the actual regulations to define what misconduct is. So again, this was letter F under 3450 has committed acts of misconduct. So if you go to now the regulations at 77.12, says misconduct in the business and practice of funeral directing within the meaning of paragraph F of subdivision 1 of section 3450, which is the law we were just talking about, shall include, but is not limited to, the following. Okay, and the emphasis is added there. Is not limited to is kind of a good phrase there. We actually had a hearing not long ago in which the firm being accused of misconduct, their defense was, well, this is not specific in the list that we're about to discuss here. This is not specific. It's not specifically listed in 77.12. And that was one of multiple items that they were being brought up on hearing for. But this was our response in front of the judge was 77.12 says, shall include, but is not limited to, the following. So what are the following? There's going to be 28 items that we're going to talk about specifically. But again, there's other things that can constitute misconduct. So because there are 28 items in the list is not real clear. It kind of jumps around. So just for clarity's sake, we've broken these items of misconduct into 4 categories. General misconduct, business misconduct, consumer misconduct, and merchandising misconduct. So because of that, these items aren't going to be in order as we discuss them. So we're ready to jump in with general misconduct. Okay, so there's, in this first category, there's going to be 4 of the 28 items that we're going to talk about. And that's pretty much items of how the licensee or the firm must interact with the department and the Bureau of Funeral Directing. So these would not be always specific to any other industry or business, but some of these do overlap. So general misconduct will be these next 4 items that we're going to discuss here. The first one looks a little familiar. Failing to comply with the provisions of the laws, rules, and regulations relating to funeral directing, undertaking, and embalming. Now, this is under the regulation. This is letter A of the regulation, the very first thing. And when I was talking about the actual public health law in 3450 a few minutes ago, I said on that list of items, the very first one was has violated any of the provisions of this article. So we have another catch-all. So if there's a statement of charges that come up for a hearing, you're not only going to get 3450A as a charge, but you're going to get 77.12A as a charge. And that's just basically saying you're not compliant. You have to be compliant. So there's kind of a piling it on, it sounds like, but that's the way the law works. Is there's always kind of a blanket thing that's going to cover the violations. And another thing I'd like to point out about the regulations and the law is that some of these things are very specific, but some of these items are left kind of open-ended, where they're not well defined. And as we go through this, I'll point some of those out. But that's basically to allow someone like an administrative law judge to make an interpretation. For example, I mentioned where we had a hearing for a firm that left a body in a morgue for multiple weeks. In the public health law, it says that you must bury or cremate a person within a reasonable amount of time. But it doesn't define reasonable. That's left up to the judge. The judge took a one look at this case and said, that was egregious. That was bad. You shouldn't have done that. So we allowed the judge to actually make that interpretation. So again, these are not in order. So A was failing to comply with provisions of the law. And C actually has two parts. Making or filing a false report or inducing another person to do so, or failing to file a report required by the laws, rules, and regulations relating to funeral directing. So again, this case I was just referring to, that was one of the things that was an issue. Not only did they leave the body in the morgue for weeks, they had already filed the death certificate stating that they had buried the body weeks before, and they hadn't. So they filed a false report. And the other gentleman I mentioned that one of the gentlemen that I mentioned that went to jail, that was one of the charges there, failing to file a report. And this came to our attention. A cemetery took a burial from this particular firm and said, where's the burial permit? Oh, I left it at the office. I'll get it to you. Weeks went by and never got the burial permit. Turns out the person that ran the funeral home never filed a death certificate. So cemetery was kind of nervous about that, naturally, because they buried the body without a permit. But that was part of that investigation that kept increasing as more and more information came forward. So the next one is letter D. Again, these are not in order. And also, if you have questions, put them in the chat, I believe is how we're doing this. And then we're going to take a break about halfway through to answer the questions. And I'll have Kelly read them out to us. So this one is revealing the personally identifiable facts, data, or information about a decedent or customer obtained in the business and practice of funeral directing without prior consent of the customer, except as, and there's a couple of caveats here, authorized and or required by law or regulation, and the second one is as necessary to complete the performance of the contract. Okay, so the first one is basically saying there's going to be times you're going to have to reveal personally identifiable facts. And that would be like when you're filing a death certificate. I'm not sure where everybody is on this call. Some of you may be downstate, some of you may be in Long Island, some of you may be in Buffalo. But I've worked in a few smaller towns where the local registrar, is, there's one county I worked in, there was I think it was 6 or 8 separate registration areas. Each township had their own registration. It wasn't countywide. And in one of the towns, the registrar was only open Tuesdays and Thursdays, had a desk on their front porch. They knew everybody in town, everybody knew everybody else. So when you're going to file that death certificate, you're revealing that information to that individual. And you hope they don't go down to the Moose Lodge or the VFW and start talking about stuff. That's their problem if they do, but you were allowed to release that information to them because it was required by law for you to file the death certificate. The second one is necessary to complete the performance of the contract. One that comes to mind here would be something like handling an insurance assignment for the family. You're going to be revealing that information to the insurance company. So in those two cases, you would not be facing any kind of misconduct for that. Now, one of the things we get calls on pretty frequently, probably once or twice a month, we'll get either an individual or an attorney representing an individual calling us up and saying, Smith & Jones Funeral Home is refusing to give us a copy of the bill, and my client is going to court to become the executor of the estate. And we got to stop right there and say, well, is your client the customer of the funeral home? Well, they're the next of kin. They're one of the children, right? Okay, yeah. They're one of the children, and they want a copy of the bill, but they're not the one who made the arrangements. So there's been a few times where we actually sent a letter back to a law firm and say, unfortunately, your client is not entitled to a copy of the bill because they were not the customer. They would have to get that from the customer. Should the funeral home release this information to you, they would be subject to a charge of misconduct under 77.12D. And that's the end of it usually. And this is always kind of a family dispute issue. And one part of the family made the arrangements, and somebody shows up and rushes to the court to try to be in charge of the estate. And, you know, probably in a lot of these situations, the individual that coming forward to be in charge of the estate was somebody that the deceased didn't have a whole lot of deep relationship with. It's usually one of the family members that's kind of estranged from the family. Unfortunately, that's often the case. So next one is delegating funeral directing responsibilities to a person when the licensee delegating, that would be you as the funeral director, the licensee delegating such responsibility knows or has reason to know that such person is not qualified by training, experience, or licensure to perform them. So here, yeah, you can't send somebody out who's not licensed. We've had a few of those. Not always easy to document. I have sent a few cease and desist letters out over the years, and yeah, it's been years. Next month it'll be 8 years that I've been in Albany at this position. Time flies, I know, but there's been a few instances where we've had firms sending out unlicensed people to do transfers. That can happen. So a cease and desist letter came out with that, and they had to put on record and write back and say this practice has ceased, and that goes in the file. So if there's any further issues like that, they would immediately go to a hearing. Wouldn't even offer them a stipulation. But notice it's not just licensure. If you, as a field director, send somebody to do something, and that person, even if they're licensed, even if they're a registered resident, if they're not qualified by training or experience to do that, that can be a charge of misconduct. This did come around. We had a consumer complaint, and again, a lot of these referrals for enforcement come through consumer complaints. And this one was from a family. Gentleman died on a Sunday afternoon, a rather large gentleman, and he passed away at home. The coroner came, signed off, said, yep, funeral home can come and do the transfer. The gentleman was wedged in the bathroom between the tub and the toilet. I'm sure you've all been in that situation at some point, but the funeral home sent 2 people, which is fine. One was newly licensed and the other one was a brand new registered resident. Long story short, there was several missteps, trying to get the body out of the position it was in, trying to get him onto a cot, trying to get him down the stairs. The cot collapsed in the entranceway, collapsed again in the driveway. The son of the deceased had to finally jump in and help them get the body into the van. And when they went to make the arrangements, they were shocked to see that they got charged extra for having 2 people at the removal. First of all, we don't allow that. And second of all, the son was outraged because he said, I'm the one that helped. I should be the one getting paid for this extra fee. So they filed a complaint with us. It didn't go to a hearing. It didn't actually go to a stipulation. The funeral home settled with the family. Once they had the complaint, they refunded them, I think, half the funeral bill, and apologized profusely, if I recall. So it's not just licensure, it's training and experience. You send somebody out that doesn't know what they're doing, you are the one that's going to get the charge of misconduct, not the individual performing that function. So that's the first section. There was only 4 items there. Now we're going to talk about business misconduct. And I just want to say that the business of funeral directing is a little bit different, as you may know, from other businesses. So some of these may be applicable to any business, but there are some here that are going to be specific to the funeral business. So let me start with this discussion here. In the when you were in mortuary school, you probably took a class, regardless of where you went, called mortuary law. And when I was teaching at Simmons, we had a generic mortuary law class, which I believe is required by the ABFSE anyways. But we had a book. It was probably a half-size, soft cover, fairly thin book. It was supposed to cover all the states, just general mortuary law and death regulation. But one of the statements in there, it talked about how if somebody wants to sue you for emotional distress, they have to show that you were on notice. In other words, any other business, if you want to sue somebody for emotional distress, you've got to first put them on notice that whatever it is they're doing is disturbing to you. And if they continue to do it, then you can try to initiate a suit. But this law book was pointing out the fact that based on the type of business that funeral homes are, there's been courts that have ruled that they are automatically already on notice due to the nature of their business. If somebody wants to sue a funeral home for emotional distress, they don't have to prove that they were given notice. And that's the language here. Funeral directors frequently deal with a clientele which may be emotionally distraught, distracted, and often elderly. For those reasons, though private businesses, funeral firms are held to a higher business standard than other retail establishments. So this very similar language sometimes is incorporated into some of our legal papers. We're bringing charges before an administrative law judge. We might point out the fact that, you know, they're dealing with this kind of clientele and they're taking advantage. I would also say this similar language is common in our consumer complaints that we get. They'll start out, you know, my father died on such and such a date. I was emotionally distressed. I didn't know what was happening. I feel like afterward the funeral director took advantage of that situation. That's probably more than half of them come in with that kind of language. So again, because of the type of business you're in, you've got to be cognizant of the fact that you're in a position that most other businesses are not in, where the possibility of abuse is possible. And again, I had somebody come up to me after giving this presentation someplace else, and they were offended that I used the term retail establishment to refer to a funeral home. But frankly, you're a private business. You sell merchandise, you mark it up, you make a profit. That's called a retail establishment. So I'm not trying to belittle or, you know, lower the standard of what we think funeral homes are. You know, it's still a calling for most funeral directors, but it is still a business. So there's going to be 8 items we're going to identify here, which is double the items that we had in the last section. And again, some of these may not be illegal in other retail settings, like a restaurant or grocery store, but there are several that are specific to funeral homes. And so we'll go ahead and start that section. And again, these are not in order. 77.12, you know, there's 28 items. So we've categorized them. This one I would think would be probably an issue in any kind of a business. Charging for services that were not contracted for, or failing to provide or making a substitution for services contracted for without the authorization of the customer. Second one, this one is specific to funeral homes. Charging in excess of the amount advanced, paid, or owed to third parties on behalf of the customers, or not passing along to the customer any discount, rebate, or other benefit received from third parties for any item, services, or merchandise described as cash advances. So there's your tip off. When it says cash advances, we're dealing with funeral homes. I don't really think of any other business that would do cash advances. I mean, there may be some, but they're not regulated like this is. We have very specific regulations, not only here under misconduct, but also when you go into 79, where it talks about the itemization. I believe 78 is on the GPL. It has some very specific disclosures that you have to do about cash advances, what can be cash advances, what are not cash advances. And the other thing before I move on to the list is it's not just marking up the cash advance that's wrong. If you get any kind of a rebate or volume discount, that has to be returned to the family. And case in point, I know one funeral home that, and I didn't even know crematories did this. There's a crematory in New Jersey that apparently gives a volume discount to certain funeral homes. So we had a funeral home down in the city that was taking, I believe it was 16 decedents boxed up in the cremation containers in a box truck. They would take them across the border to New Jersey, and it turns out during an investigation on an issue that found out they were getting a volume discount. So they put one price on the cash advance list for the family, but in reality, when all was said and done, they were paying less than that. So that technically should have gone back to the family, that difference. So here's the list. We'll go through this briefly. There's a couple of comments I want to make on this. This is in regards to cash advances, and it's right here under the regulation 77.12. This is letter K continued. Cash advances shall include, but are not limited to, the following services or merchandise. So I got a list of 9 items here. These are always cash advances, but that's not the only ones that can be. Get into that in a moment. Cemetery or crematory charges, always cash advance items. We did go to a hearing, I think it was just before COVID hit. We had a hearing about a funeral home that was in the southern tier. There were multiple items that we were addressing or trying to address. But one of the issues was we found out they were marking up the crematory charge. Their defense, as you might want to call it, was they were taking the bodies to a crematory in Pennsylvania. Therefore, they didn't think that applied. That they thought that only applied to New York crematories. That is not the case. Any cemetery or crematory is always a cash advance. So you cannot mark that up at all. As long as I'm on this topic, when I say cemetery charges, there's been some discussion about cemetery equipment. I prefer the term gravesite equipment because cemetery equipment sounds like the cemetery owns it. So we've had this discussion with in several venues. If you own the gravesite equipment, the lowering device, the tent, the chairs, whatever, if you own it and you provide it, you can charge whatever you want. Okay? If the cemetery owns it and the cemetery provides it, it is a cemetery charge. You cannot mark it up. And we got this middle ground about the vault company. At least upstate, I think 90% of the funeral homes, the vault company provides the gravesite equipment. And that is, they have a separate price for that. When you do business with them, you know, you got your grave liner, you got your vault number 1, vault number 2, and then you mark them up on your price list. That's fine. That's perfectly legal. If they have a charge, you know, for the gravesite equipment, there's 2 ways you can handle that. You don't have to do it as a cash advance, but you're welcome to. And just like any other item of merchandise under additional goods and services, you can mark that up. So if the cemetery, if the vault company charges you $150 for the setup, you can charge the family $250. You can charge whatever the market will bear. You can mark that up. And again, if you own the equipment, certainly you can mark it up, whatever you need. But you are welcome to also do that as a cash advance item. You don't have to do any kind of merchandise as a markup. You can always do it as a cash advance. If you did that with everything, you'd probably go out of business pretty quickly, though. The second one is clergy honoraria. And again, you obviously can't mark that up. I would throw in here among clergy, a soloist or an organist or any other kind of functionary that's part of the services that is not part of your payroll. And then that question comes up, well, we sent 2 of our staff to become certified celebrants. They're on your staff, you trained them, you paid for the training, you make it clear to the family, this is a funeral home charge. They're not clergy. A certified celebrant is not a clergy person, it's not an honoraria, you're charging them for a specific service. So that's a little bit different. Death certificate transcripts, again, this is going to be certified copies. And there's some other documents that are charged for, my understanding. And again, in New York City, in the 5 boroughs, they have a requirement if anybody's going to be cremated, there's supposed to be a separate cremation authorization from the Office of the Chief Medical Examiner. And I believe it's like $40. And I've talked to a couple of people down there that say, yeah, we mark that up because it's not a death transcript, and we have to drive all the way into the city to get it, et cetera, et cetera. I guess apparently that flies. I don't know about in other areas if they have any kind of a permit like that. Number 4 is referring to traffic escorts. If you pay for a traffic escort, there are some venues in which that's common. In my experience, we used to have the local police would do it if they were available, and sometimes we would use the Patriot Guard. We would give them an honorarium the family would give them an honorarium. But certainly we couldn't mark that up. Chevre Kaddish or any other kind of religious group that comes in and does any kind of a ceremony or preparation of the remains, that's whatever fee or donation they receive, that cannot be marked up. Public transportation, common carrier. If you put someone on an airline to send them to another state or someplace else, you cannot mark that up. We did have one complaint in which the funeral home actually put the actual air bill on the cash advance side, but under additional goods and services, they put another $500 charge for airline. And the family's like, what's this all about? And the funeral home's defense was, well, I had to make the calls to get the flight arranged. Well, that's part of your basic arrangement charge. You can't charge separately for that. Also, as far as public transportation goes, number 8 you'll see is bridge and road tolls. I'm skipping 7 for a minute because I'm going to come back to that. Situation again in New York, where we had a firm that was taking multiple remains into New Jersey for cremation. They paid 1 toll, and every family got that toll put on their cash advances. So they paid 1 toll, they got reimbursed for 6 or 8, whatever that was. You can't do that. That's considered a markup. Telephone and telegraph charges, again, I've never sent or received a telegraph in my entire life. With modern technology, I can't remember last time I saw a phone bill. But I'm going to back up here and go to gratuities. The reason I pull this one out separately is if you go to another section of the regulations, we're in 77.12, of course. If you go to 78.1D2, I believe it is, it gives a list of all the documents that you need to keep for at least 4 years. And again, your record retention is only required by the state to be 4 years. I know most funeral homes keep them indefinitely, but we won't go back and demand documents older than 4 years in general, unless there's a reason to. If you don't have them, you don't have them. If you do have them, you have to turn them over if we request them. But it's rare that we would ever request documents that go back that far. So 7 is gratuities. And this is the one item on that list of 9 that you do not have to keep receipts or cancel checks for. And it's because gratuities traditionally are in cash. But we have had that question come up in the past. We had a call not too long ago, very recently. A family called looking over their itemization, and they said, well, we got a concern here. We got charged $500 for gratuities. This is downstate. And we called the funeral home and they didn't know they couldn't tell us what it was for. Well, the first problem was it was almost a year after the service. And that is something I've noticed at the Bureau. A lot of the concerns and complaints we get come sometimes a whole year after the fact. I believe that's because the anniversary of the loss sometimes trigger the family member to go and pull out the file and look back and see what they got and what they didn't get. And they'll call us, oh, I don't remember getting thank you notes, but I was charged $40. In this case, the gratuities, the complainant called the funeral home and they said, we don't remember who we gave it to. So it's not required and you don't have to keep it for 4 years, but just a common recommendation that we would make is if you do pay out a lot of gratuities, just throw a list in the file. So if the family does call a year later, you can answer the questions. So that's end of subdivision K. Subdivision O is going to be probably 5 slides. There's 5 sections of misrepresentations that we're going to talk about, and then I think at the end of that we'll take a break. So it's all about misrepresentations, these next 5. So number 1, letter O, subdivision 1, paragraph 1, no, subdivision O, paragraph 1. I can never remember how this nomenclature goes. But misrepresenting the law or the public health necessity, including, but not limited to, representing that state or local law requires that a deceased person be embalmed, or that a casket is required for direct cremations, or that outer interment receptacles are required, or any purchase of any goods or services requirements. Such is not the case. Then there's the or at the end, which means we're going to go to number 2 here. I want to point out here, misrepresenting the law or the public health necessity. First of all, I want to say it was a tough year in 2020. Starting in March, everything shut down. There was a lot of confusion. There was constantly changing landscape, constantly changing executive orders, CDC guidance. We sent out some guidance. And I just want to say that 99.9% of the funeral homes did an outstanding job, worked hard to get through that, to try to navigate that situation during COVID. And, you know, I'm proud of the way most of the industry responded. Unfortunately, there were a few that did take advantage and misrepresented the public health necessity. Some did it by accident, obviously. Again, things were changing, things were being redirected and rescinded and then put back up, and it was a little confusing at times. But there were some individuals, this hearing I mentioned that we had last fall, one of the items that the funeral home was charged with was during COVID. They misrepresented the public health necessity, stating to some families that sealer caskets were required. Nobody ever required a sealer casket. There was another firm that was telling the families that the heavy-duty orange disaster pouches were required for the cremations. That was never the case. They were saying that the crematory, in fact, we discussed this with the Division of Cemeteries, they were claiming that the crematories were requiring that. Crematories were actually telling people, please do not use those. They give off a lot of intense smoke. During the height of COVID, there's only 4 crematories in New York City. One of them had to shut down for 72 hours because of the emissions, and the emissions issue was caused by these heavy-duty body bags. So again, I mean, this is at a point during COVID when, if you were in the city, if people on this call that are from the city probably remember this, where it was one crematory, it was a 6-week wait for a cremation spot. So that was terrible to have to shut one of the crematories down for 72 hours. But again, you can't misrepresent public health law or the public health necessity. You can't tell them that embalming is required if it's not for, you know, for their services. Outer interment receptacles are required, and most cemeteries do require them. There are a few. I did this presentation in Rochester a few weeks ago, actually less than 2 weeks ago, I guess. And I asked to, you know, show of hands if anybody in that area still had a cemetery that didn't require an outer interment receptacle. There was a couple of hands that went up, so that's still out there, but not common. So that's 01. 02 is misrepresenting cemetery or crematory regulations. I have down the same lines, including but not limited to representing that such regulations or requirements require a deceased person be embalmed. It's almost the same language again here of number 1, or that a casket is required for direct cremations or outer interment receptacles are required when such is not the case. We did have a complaint at one point, and a woman had called us regarding, she never filed a formal complaint. I guess we had a long discussion on the phone and then with the funeral home. And she got a refund, but she had buried her husband in the local cemetery. And the funeral home said, oh yeah, you absolutely have to have at least a grave liner. Sold her $800 grave liner, and they did the burial. Things were good. 2 years later, her neighbor died and was buried at the same cemetery. And when she went up as part of the congregation at the committal, she went to put the flower on the casket, and she glanced down in the gap and saw there was no enclosure. So on her way out, she saw the cemetery personnel standing over the side. She walked over and said, "How come they don't have that concrete box in there?" And said, "We don't require that." Oh, so that was news to her. So that led to a call to the Bureau, which led to a call to the funeral home, which led to a refund and an apology. Of course, his defense was, "Oh, I thought they did require that." So that's not always a good excuse. Number 3, misrepresenting religious requirements. Okay, it goes on to say this shall not include differences in interpretation of religious requirements. Rule of thumb, good practice. If you're not a lawyer, don't give legal advice. If you're not ordained in some fashion or certified in some congregation, you shouldn't be giving religious advice and interpreting that stuff. Leave that to the experts. Save yourself a hassle, because it's not only just bad practice, but again, it could be a charge of misconduct if you purposely misrepresent religious requirements, of course. The fourth one is misrepresenting that a deceased person is required to be embalmed for direct cremation, for direct burial, or for funeral using a sealed casket, or for funeral without viewing or visitation when there's to be a closed casket. I mean, this sounds pretty straightforward, but there's some things you can read between the lines here. This is saying that you can't misrepresent that they have to be embalmed. They're going to have a closed casket. So you can't require embalming if there's a closed casket or sealed casket. You can, however, require embalming for an open casket visitation. You don't have an extra charge for open casket versus closed casket, so it's the same charge on the GPO for visitation. Whether open or closed, if they want it open, yeah, we require embalming. So the law does allow you to have that requirement in your firm. There's nothing that, and again, we've had funeral directors that misrepresented the families that if you have an open casket, the law requires the body to be embalmed. The law does not require that at all. But you can have that requirement. Conversely, if you want to be certified by the Green Burial Council requires you to offer and allow open casket viewings with unembalmed bodies. I don't know if they've changed that in the years since I've been here, but that was their stance originally. So, number 5, and then we're going to take a break at this. Misrepresenting that a casket other than an unfinished wooden box is required for direct cremation, or misrepresenting that any other container is required by the crematorium when such is not the case. And again, this goes back to COVID, where we did have the one firm that was telling the families the crematory requires this heavy-duty disaster pouch. That was not the case. And obviously, you can't tell them that a casket is required. Now, if you go to another part of our regulations, there's a section in our regulations that gives a list of definitions. I believe it's very early in the regulations. I don't have them in front of me. But one of the things they define is an alternative container. And again, you have to offer an alternative container for cremations. And one of the items on the alternative container definition is pouches of canvas or other material. Now, where we come into this as an issue, I don't think any of you are taking bodies to any crematorium in New York State with just a pouch. There may be states that allow that. I'm not aware of that. New York State crematories, under the Division of Cemeteries, which is under the Department of State, requires a rigid container, at least a cardboard box, something rigid. So you cannot go to a New York crematory with a body in a body bag. But as far as what kind of alternative container you offer, that you're going to offer in New York State, you can have your minimum container as just a plain wooden box, an unfinished wooden box. I know some funeral homes, that's what they offer, and they charge accordingly. And if the families don't like that and they want something less expensive, they can go elsewhere. I've seen some funeral homes use the cardboard boxes and mark them up to $500. And the families call and they say, I think that's outrageous. And I say, I think it is too. You should have picked a different place. Because we don't regulate the prices. So I believe that was it for this. Oh no, yeah. We'll hold off here. We're getting into a whole different area and we're still in this subsection. I'm going to pause here and see if Kelly has any questions for me, and then we can take just a quick break.
Yeah, Tom, we do have a few questions. They're ranging in subject matter, so I'll just start from the top. If we want to keep an active status, but we will not be employed to a specific funeral home, on the renewal application, do such questions get left blank or filled in with an NA?
Well, we have some people that keep an active license because they're trade people, and some of them are very thorough with their applications. They'll attach a separate sheet with like 16 firms listed on it. Unless you're employed full-time at the same firm, in that section, you could just write in multiple firms or trade work or something like that. It's, ultimately, this is not something that's regulatory on there. It's just kind of a kind of gathering some information to help us if there is an issue down the road. So it's not going to, it's not a deal breaker if that's blank. But if you are full-time at a funeral home, please indicate that. And certainly if you're a manager, you have to indicate that.
And before I read another question, I'll just remind everyone, if you want to ask a question, the right-hand side of your screen has a pane that will allow you to type in the question. If an attorney's office calls to request a copy of a paid invoice, are we not supposed to provide it?
The copy of, I'm sorry?
Of the paid invoice.
Not without the customer's permission. In fact, that's where I was saying earlier, you could be charged with misconduct if you release that information and the customer is not aware of it or does not get permission. And again, it's usually a family dispute. You got somebody who's kind of estranged from the family. They find out that their old dad died that they didn't speak to in 10 years, and they're going to rush forward to the courthouse and try to pick the bones. And, we run into that all the time. So you got to be careful about releasing information. The other one I've had is people come up to me and say, oh, can you give me a copy of the death certificate so I can get a discount on my return ticket on the airline? It's like, talk to the widow, talk to the, the person who actually made the arrangements. We can't do that.
If someone dies at home and the licensed funeral director arrives at the home and realizes the deceased is severely decomposed and he or she cannot successfully remove the deceased from the residence, may they ask the county medical examiner to remove the deceased to the county morgue?
It would depend on the county. Some counties would probably laugh at you and say, too bad, the family chose you and you're the one. If the family's chosen you and the county coroner has released the call to you, it's your duty at that point to proceed on behalf of the family. Basically, when they release a body, they're not really releasing it to the funeral home, they're releasing it to the family, and the family has hired you to go and do a specific task. So unless the family's walked away from it, and oddly we do get that, unfortunately too frequently, where family will just walk away from a call and not respond, and you're stuck with the remains, then it becomes an abandoned body. It's kind of a different scenario, but yeah, certainly you can ask for the coroner's help. It depends on the county you're in, if they have a morgue. A lot of counties don't, particularly upstate. I know of several counties that they don't have their own morgue. They contract with a local hospital as a temporary morgue, as a holding area. So that would be a county by county basis. I've been on house removals where it wasn't severely decomposed, it was just a very large individual. And we just took the family in another room and explained the situation. We called the local volunteer fire company and gave them an honorarium, and they helped us get the body out. But whether or not the coroner is going to jump in and do that, that's going to be up to the county.
Okay. Can you release a certified death certificate to any immediate family member?
No. Again, that's if there's a family member that's not the customer and they want a certified copy, you direct them to go to the local registrar, and they've got to prove that they're entitled to that copy. Again, if you do that and it turns out that they shouldn't have had it, again, under misconduct, you've released the personally identifiable facts of the deceased or the customer. And yeah, again, without the customer's permission. And here, I just want to point out, the term customer is kind of touchy rather, because there may be multiple individuals that have the same right of disposition, but you should always narrow it down to one person that's going to be the customer, because we've had some convoluted complaints where, there was 4 kids and one signed the cremation authorization and one signed the CDI and one signed the itemization, and it's like, why did you do that? Well, I wanted them all to have a piece of it. Like, no, keep it on. That's why you're going to court now. Yeah, the customer should be one individual. If you do have multiple siblings that are all equally eligible for control of disposition, have them sit down with you and say, okay, let's just work with one person. Everybody in agreement that, you know, Brother John's in charge, and go from there, and have him sign everything. I guess I'm done.
May an unlicensed person deliver a deceased to a medical school?
Boy, that's kind of an unlicensed person take a deceased to a medical school. Is there going to be a licensed funeral director at that end? Generally, the ones that I'm familiar with, there's usually a licensed funeral director at that end. It is in the law that a mere transporter does not need to be licensed, but they do have to have a transit permit. That's the reason it says that is otherwise every airline pilot with a body in the hold would have to be a licensed funeral director. So once you have that burial transit permit and that's attached to the outer container, anybody can be driving that vehicle. Where we get into the issues, it has to be a person with a license that's releasing that body to the mere transporter, and a person with a license receiving that body from the mere transporter. So if you are sure and absolutely certain that the medical school has a licensed funeral director on site that's going to sign that body in, that would be fine. I know several funeral homes on the southern tier. There's multiple crematories in northern Pennsylvania, probably because it's so hard to build one in New York. There's actually some funeral homes in the southern tier in New York that have built crematories in Pennsylvania. And yeah, once they have the burial transit permit, and that's on the, you know, that's present with a body, they can have anybody take that body across the border into Pennsylvania. So I guess the same thing would apply to a medical school.
Can you review the definition of a domestic partner when it comes to New York State and cremation?
Yeah, this comes up every time because the law in 4201, where it talks about domestic partners, it gives a lot of tests that you can do, but it's not required that you check off every box. So there's a lot of things. Do they live together? Do they have any children together? Do they have a joint checking account? Are they both on a lease? Is one of them on the other one's insurance? All those things can be used as a determination. But what we always tell funeral directors when they call, and we had a call last week, a couple had been together for 15 years, had a 14-year-old daughter, same checking account and everything, and the mother of the deceased was disputing everything. And we told the funeral home, you are not the one to adjudicate that. First of all, if there's nobody challenging it and somebody comes in and says, I'm the domestic partner of the decedent, I want to be in charge, you have them sign the at-need statement that they're the person in charge. And as long as you're acting in good faith and they're acting in good faith, that piece of paper covers you. When I did the 4201 presentation a couple of bienniums ago, I had some court cases that I had printed out and that I brought up. And one of them was a funeral home that was being challenged by somebody else, and they didn't have that piece of paper. And the judge ruled, you don't have that? You don't have that statement from that individual? You're not covered. They can go ahead and sue you. So again, just like when we talk about religious functions and legal things, you do not adjudicate whether or not that person is the domestic partner. If anybody comes forward and wants to dispute that, which is the case we had earlier this month talking about, you step back. The 4201 also says that you will be held harmless for not doing anything or not moving forward until it's been adjudicated by a judge. So the family has to go, I think that's subdivision 8 of 4201, where it says any dispute over the rights of disposition, the disputing parties need to go to the court of competent jurisdiction. And in our experience, has been a couple of times where we've known this has happened. The court usually puts that at the top of the docket and moves forward pretty quickly. Thank you.
Can a funeral home require an embalming if holding a body more than 4 days, even if it's closed casket?
No, you cannot require embalming other than for an open casket funeral. Had a situation like that where, well, actually, let's come to that further down the road here, but you always have to have permission of the family to embalm. If they don't like it, they can go to another funeral home. And again, you can't just have this blanket thing that I'm going to charge you for embalming. I had a funeral home that did that, and their defense was, my policy is If they're here more than 48 hours, they have to be embalmed. But you can't have that kind of a. There's several religious groups that have absolute religious ban on embalming. You couldn't do that with a Muslim family or a Jewish family. You'd be sued. You'd be in court pretty quick if you did that. Anytime you do embalming, you have to have either written or oral permission. In fact, I think that's one of the slides coming up in the second half here.
Can a funeral home charge for a body if multiple bodies are driven to the crematory in one van?
I'm not clear on what they're asking. I mean, if you're, okay, I think I understand. Part of your cremation charge is transportation to the crematory. If you have 4 bodies in a van going to the same crematory, does each family get charged? Yeah, unless you're paying a toll and charging the families, all 4 families, the same toll. You're providing that service to the family, you're entitled to be paid for that. Whether they share the ride or not, that's one thing you may want to disclose to a family. But again, you're providing that service of the transportation to the crematory. Certainly that you're entitled to be paid for that service that you're provided for the family.
And this goes back to the cremation or the embalming question. If the visitation is delayed for days, can you then require embalming?
Again, the family has to give their permission. You have to explain that to them. I mean, you haven't run into this specific example, but if a family comes in and they say, well, we want to wait 2 weeks for the visitation because grandma's in Florida, you can tell them, I strongly recommend that there's an embalming. If you have objections to embalming, maybe you can arrange refrigeration for the family, or unfortunately you may have to say, well, I can't help you. You may be able to find another funeral home that can. But again, you cannot require embalming other than the open casket visitation.
Is the funeral director required to tell a family that a licensed funeral director is not required to be in the cemetery for burial of cremains?
They're not required to state that. I mean, the burial of cremains, a family can go and do that. I've had many families over the years that went to the cemetery on their own and arranged a burial and put up their own service and everything. So there's nothing requiring a disclosure. I think it's good practice to let them know that, yeah, I'm going to have one of my other staff, assist for the burial of the cremains. But cremains are a whole different creature. It's like they're human remains, but they're not human remains. As far as the public health law and funeral directing goes, the final disposition happened at the crematory. And we don't take a specific interest in the cremains after that. But when you talk to the Division of Cemeteries, when you bring that box of cremains through the cemetery gates, they suddenly become human remains again. And they got to document it. They've got to, do all that. But there's nothing in cemetery law either that would require a licensed funeral director to be present for that.
Can you require a sealed casket in lieu of embalming if there's a significant delay in services?
You can strongly recommend it and explain. And when we get into the merchandising misconduct, we'll talk about that. But yeah, I mean, you strongly recommend it. And there's all these questions about, can you require this? Can you require that? It's tough. I mean, strongly recommend, or this is our policy. If you don't like it, go down the street. I mean, those are tough kind of decisions to make. And again, we get families that say, well, I was pressured into doing this. And then they end up, getting an order and stipulation. You explain why you did it that way, or something of that nature. So you just got to tread lightly when you're talking about requiring things.
Can a friend authorize cremation when there is no family?
A friend? Oh, sure. If you go down the list in 4201, it keeps reaching further and further afield for somebody who can be in charge. And again, that friend, as long as they sign that need statement saying, I think I'm the only one on this list that's available, We even had situations where there is somebody known has more standing, but they're unavailable or unwilling to come forward. You're allowed to move down the list. So let's say there is a son in the mix. The decedent has a son, an adult son. Nobody can find him. He's homeless, and this is a common one we hear. Last we knew, he was in a rehab in Tennessee. Okay, go ahead, move forward. He's not available or able or willing to come forward. So as long as, again, you have that at-need written statement signed, you're covered, and you act in good faith.
I recently heard that non-New York State funeral homes and funeral directors that border New York State are allowed to make removals from hospitals, nursing homes in New York State. Is that correct?
New Jersey is the only one. We still have a 1968 written signed agreement with New Jersey. I think it dates back to when the airport opened at JFK and bodies were coming in. That was the closest airport that would serve New Jersey for transfer of remains or receiving remains, rather. And there was a reciprocation agreement signed with the state of New York and New Jersey that allowed funeral directors to come into the state for transfer of remains from the state or for final disposition. Ultimately, there are several New Jersey firms, for example, I think there's some in Pennsylvania and Connecticut as well, that are on the EDRS system. So they've been able to sign up with New York State Vital Records as long as they have a New York licensee that can sign that on their staff. So there's some limited reciprocity there, but again, the agreement we had with Massachusetts and with Vermont and Connecticut and Pennsylvania, those have all expired years ago.
Can you discuss the fee for burial transit permit to family? It can't be charged to them, correct?
The $20 fee, that is correct. That was the original agreement. I just saw my legislative report for the cemetery board meeting last week that that bill came up again to get rid of the fee, and it was passed both houses and then vetoed by the governor. So the fee stands at least till the next legislative session, I guess. But yeah, the original agreement was that it would not be charged to the family.
Okay, so this also goes back to the embalming. Can you require a family to purchase a seal or casket if unembalmed body for more than 4 days? So I think that's the same question.
Yeah, I think we already dealt with that one. Yeah, you can never require embalming other than if they select, because they have an option with an open casket. That's the difference. But if you're putting this absolute mandate on them that they have to be embalmed, you can't do that. With the open and closed casket, they have an option. You want it open or you want it closed? I want it open. Okay, then you got to have embalming. Okay, well, let's close it. Or I choose a different funeral home. So that's the difference, is that with open and closed casket, they still have an option.
So this question is regarding transporting body. Just to confirm, you don't need a licensed funeral director to deliver a decedent to Pennsylvania crematory if you have a burial transit permit in hand. That's
correct, right. Yeah, because Pennsylvania does not require, apparently, to have a licensed funeral director at the receiving end. So if you're taking a body out of state, you've got the burial transit permit, anybody can be driving that vehicle. It's just like if you put them on a train or something like that. But if it's within New York, you're going to a crematory in New York, there's got to be a licensed funeral director at that end to receive the remains. Out of state, we don't regulate.
Is it permissible for an unlicensed person to take custody of a body, take it to a place of worship to wash, and transport it to the cemetery, all handled by someone unlicensed?
No, you would have to have a licensed funeral director at the cemetery. And again, if they were moving that body for any other reason, they have to have a burial transit permit accompanying that body. The person releasing it to that cemetery would have to be licensed, and then the person receiving it at the other end would have to be licensed.
Are we obligated to order certified copies for multiple children if they want to pay for them, multiple copies of death certificates?
Are you obligated to? No. There's some funeral homes that say we're not in the death certificate business. It's a cash advance. We don't do cash advances. And frankly, no funeral home is required to do any cash advances. I know a couple of firms that are like that. They hand the family an envelope with a list of checks for them to write, and they say, we'll be happy to distribute these for you, but we're not fronting the money. I had one old timer tell me his statement he would tell families is, I got an agreement with a bank. I don't loan money and they don't bury people. And that was, and he refused to do cash advances at all. So no, the funeral home is not obligated to order any death certificates for that matter.
A family approached me with a prepaid pre-need arrangement, but the funeral home closed 20 years ago, and the people that owned it are all deceased. What can I do to assist this family?
Yeah, we've run into a few of those in the last couple of years. The first thing we tell them when they call us is, where were you getting your statements from? And the answer is invariably, what statements? I never got any statements. Basically, the money's gone. Twice, I think we've had luck with telling them to contact the comptroller's office. There's a website for unclaimed funds. You know, some of these people had, you know, pre-needs that were put into the local bank, and then the local bank sold 4 or 5 times, and the money ends up being turned over to the state. So if they got the deceased social security number and name, they may be able to make a hit on the unclaimed funds section of the comptroller's office. I think we've had at least 2 cases where that was the case. But again, the comptroller will hold the money. They won't pay you interest. So depending on how long ago it was turned over to the state, you know, you may end up with a $2,300 cremation, but there's only $500 in the account. So what you can do to help them is, you know, just guide them in that direction and see if they're eligible for any other assistance.
Okay.
This has been the most questions I've been at the break ever.
I mean, I hope we may not get through the rest of your slide, but the Department of State Cemeteries 3-pager on page 2 and 3. The person in control of disposition doesn't match the at-need written statement of person having the right to control disposition. Is this something that will be modified in the future to be the same written language for ease of understanding by the funeral director and customer?
Yeah, you know, actually, I've had this discussion offline with Louis Polishuk. There's a legislation pending that's going to change 4201, and there's no reason why it may not go through. And it's a rare occasion they're going to put this instead of the 5211 appointment of an agent form as number 1, it's going to be this form DD93 from the military that would supersede everybody, including anybody appointed in the written designation. So when that bill came up and started working its way through the legislature, I talked to Louis about this, and I said, you know, you're really going to have to update the cremation authorization to list this as well, and let's just make sure everything's, you know, copacetic and matches from our side to your side. So there's, you know, there's opportunity to correct that. Certainly 4201 supersedes whatever they have on their form. Theirs is just basically trying to capture what you have already determined at the funeral home.
We have had bodies that started to smell within 2 days of the house removal. In that case, we definitely can't require a sealer casket or embalming. Who's responsible for the decomposing of the body?
Who's responsible? Nature is responsible. Yeah, again, this is some of the delicate areas you deal with a family. You explain the way that you know, nature has a way of reclaiming its own, and you know, Dad's no longer here. What's left of him is not holding up very well. I had to make that call once, and it was a really tough phone call. I paced back and forth in the office for an hour before I picked up the phone. or I had to tell this widow, you're not going to be able to see your husband. And eventually she understood. But you know, the guy had been on chemo and all kinds of other drugs, and she just she didn't want him embalmed. She just wanted to come in and say goodbye. And it's like, I don't recommend it. And she was okay with it. But again, it's, you know, in these situations, you just gotta do the best you can. And you know, part of being a funeral director is counseling the families and giving them options and telling them the truth about what's happening. I don't know if I answered that correctly, or hopefully I did.
Yeah, I mean, yeah. If a pre-arrangement is made by a person and at the time of death, the next of kin wishes to make changes to that pre-arrangement, can we do so? Also, if the individual who made the pre-arrangements for a family member wishes to make changes, can they do so?
Okay, so if I understood the question correctly, again, we did this under 4201. 4201 says that if you know the wishes of the decedent, you're required to follow them. Now, there's two things with a pre-need. There's a purchaser and there's a beneficiary. Probably 80% of the time, the purchaser is also the beneficiary. In other words, they buy their own pre-need. In those situations, you have to follow that pre-need. If the family, if you have a daughter or son that came and made a pre-need for their parent and they were the purchaser, they're allowed to make any changes they want. And I had a funeral director call me a couple of years ago, and he said, I got a family, I got son and daughter here. Dad died years ago, mom just died. She did a pre-need with me, and they want to change everything. And you know, mom had made her own pre-need and made her wishes expressly known. And he said, well, if I don't do anything, what's going to happen? I said, well, who's going to, I mean, technically, who's going to complain? The son and the daughter are the only ones that are going to complain. So he didn't tell me which way he was going to go on that. I said, those are your options. I mean, follow it as required, or take your chances. I mean, if one of the children changes their mind later and says, hey, you didn't follow things, you know, what's your excuse then? But again, I mean, it's minor variations is one thing, but you know, completely changing from burial and services to direct cremation, that's a huge change. And if that's the person who made that arrangement for themselves, if they were adamant that they wanted to have a burial and a service, and you don't follow that, that's you know, that's egregious. You shouldn't violate that trust.
Are you required by a law to fill third-party purchased cremation merchandise, for example, keepsakes and pendants, in the same manner as funeral merchandise?
Okay, yeah.
Like utilizing, yeah.
In other words, a person brings, they come back with a box of cremains and all this little jewelry they bought online. You're not obligated to do anything. Once you hand over those cremains, that's theirs. But you are also totally welcome to put on your GPL, and I've seen this multiple times now. You know, actually, I saw the word inurnment. Inurnment of cremains to earn that was not purchased at our firm is such and such a charge. As long as it's on the GPL, you can charge whatever the market will bear. I always hated putting ashes into jewelry. It was like, we actually had a little tea sifter to get the finest particles we could. And then those things never threaded back in correctly. But anyways, I digress. Yeah, whatever you do for family, first of all, you're not obligated to do it at all. If you do it and offer it as a service, put it on a GPL. And when they come back to you and you say, oh yeah, it was a $100 charge, they're going to be like, oh, okay, well, maybe we'll do it ourselves. And you can also charge for doing it with your own merchandise as well, but most firms don't do that, in my experience. Okay.
Yeah.
Maybe we should just do an hour presentation with an hour of Q&A at the end.
That's what I'm thinking. We could definitely fill this up. Yeah. Okay, so going back to the question regarding wanting to embalm the body, but maybe the family isn't cooperative. can you refuse a visitation at that point? If the body has decomposed, maybe not smelling the best, can you refuse it?
There's nothing that specifically addresses that in the public health law about refusing to hold services. You could certainly say, this could be a public health hazard. I mean, again, you can't misrepresent the public health necessity. But if you believe that this is now crossing the line, you might even want to get the county involved, have the county coroner come in and make a statement, examine things. I don't know how likely that is in some locales, but I know that happened once when I was in Syracuse. We actually had a Onondaga County medical examiner, but back then it was, oh boy, I almost said his name, but anyways, Eric Mitchell. He came and met with a family. We had a case where just spontaneous tissue gas overnight. Family saw her in the hospital bed the night before. She died. They put her in the morgue. Funeral home came to pick her up the next day. Loaded right up, bubbling. It was bad. And the medical examiner came and explained to the family, why they could not have the services. But if you feel it's a public health hazard, get the local authorities involved. But certainly you got to take time to explain to the family what's happening.
Why does the cremation authorization form require a family to reveal what their plans are for the cremated remains? Some family members feel that is none of our business. And why is that section termed final disposition? Yeah,
this is, again, we don't regulate the 1898 form from DOS, the 3-page cremation authorization. That's a question you could certainly email to them, why they have it structured that way. But we don't have any regulatory authority over the cremation authorization.
And this question goes back to changing prearrangements. What if the children seek to make radical changes to a prearrangement, like making a full burial down to a direct cremation, and refuse to sign the at-need contract?
No, if they refuse to sign the at-need contract, they're not a customer. I mean, plain and simple. Show them where the door is and thank them for their time. Again, this is a common issue there. They come in and try to change things. Mom had money, she put this all together for herself, and then the kids come back in and say, no, we're not going to spend that. Again, who's the customer? I mean, who's the purchaser? Who's the beneficiary? Is it revocable or irrevocable? There's all those things to consider too. And I did have that situation happen to me one time where the children wanted to change the arrangements, and it was an irrevocable case. And I said, if we change the arrangements, that money's going back to the county. You're not getting it. And they were not happy with that, but that was the case. So, I mean, there's a lot of variables there. But again, 4201 says if you know the customer's wishes and it's possible to follow them. I mean, they can't ask for a pyramid in Egypt or something like that. But if they've already funded this and they've selected the items and the services they want, you have no real excuse for changing it.
Okay, 2 more questions.
Okay.
Can you clarify the reciprocity between New York State and New Jersey? Are New Jersey funeral homes limited to New York City airports and other things, or are they allowed to make removals throughout the entire state of New York?
Okay. I'm sorry, the last part was not clear.
Are New Jersey funeral directors allowed to make removals anywhere in New York State or only New York City?
Oh yeah, anywhere in New York State. It's a state agreement. Yeah. So if you're a New Jersey funeral director and you get a death at Upstate Medical in Syracuse, you got the time to drive up there, go for it.
Okay, and the last question for now. When breaking down the pricing for a gathering or visitation on the website, do you have to itemize each breakdown line by line with a price and then total the entire cost, Or can you list what is included with the gathering or visitation line item by line item and leave off each individual price break and place the total of what the breakdown of the itemized services include for the gathering or visitation? And if that is a very confusing question, we can probably get it more of an email conversation.
Yeah, I'm not really clear on this, what they're breaking down here. I mean, as far as a gathering, I'm assuming they're talking about the supervision of services for a visitation. Yeah, that might be one that's better dealt with in an email.
Yeah, I believe so. Okay, so that's the end of the question.
Wow, all right. Okay, so we'll jump back into our slides. And actually, I want to thank you all for the questions. I've done a few of these where, I hear crickets when I ask for questions, and I finish a half an hour early. So that's not going to happen this time. But I do appreciate the questions. Any chance I can get to, to clarify and make things more simple. Okay, the next two things we're going to talk about in this, as we wind down this second section here, I call this section the watching your P's and Q's. There's been some historical debate about where that term comes from, whether it's pints and quarts at the tavern back in colonial times or printers getting their P's and Q's backward on the setting type. But P is obtaining custody of a deceased human body without having first received from the customer explicit written or oral authorization. It doesn't happen too often, but we do get calls on this. And usually it's a confusion because there's a split in the family, and one half of the family calls one funeral home and one half of the family calls the other funeral home. And now we have the situation where the second half of the family is accusing the first funeral home of not having authorization. A question came up 2 weeks ago in Rochester about this. You get a call at 2:30 in the morning from the local nursing home, and they say, yeah, Margaret died and the family wants to use your services. Do you have to call the family at 2:30 in the morning and get their oral authorization? I would always ask the nursing home at that point, is there a face sheet where the family's signed off that to contact me? Because if that is the case, then you have written authorization. So let's go back to this situation where you have a split in the family, and half the family calls Smith Funeral Home and the other half calls Jones Funeral Home. Jones Funeral Home gets there first and they have the body. Finally turns out maybe after 4201 subdivision 8 that they go to court and Smith Funeral Home gets the call, or they just agree that this other side of the family has it. You have to promptly release the body if you do not have the official person in charge authorizing you to have that body. So whether it's just a mistake in communication that is why you ended up with this individual in your care, you have to release them immediately. And we have this one going on. We just had this call the other day. Funeral home A got body, funeral home B is entitled to it. And funeral home A says, you can come and get the body, but I want a check for $400. You cannot hold a body hostage. You have to promptly release the body or give information in regard to the release or care or whereabouts of that body. So are you entitled to be paid for having done the transfer? Yeah, you are. Whatever you've done, you're entitled to be paid for it. And the person who authorized you to do that transfer, even if they weren't the person in charge of disposition by law, they're the ones who engaged you, and they're the ones that need to pay you. They can do it as a cash advance to the second funeral home or however they want to do it, but you're entitled to be paid for what you do. And I've had that happen to me where a family changed their mind, and the day after they made arrangements with another funeral home, and they came and said, actually, we think we want your funeral home to handle the call. So I went to the first funeral home to get the body, and they were refusing to release it. And it's like, that you take that up with the family. The family finally did. They paid that first funeral home directly, and they had no problem with that. Okay. Indicating interest charges or finance charges unless written disclosure is contained on the statement of itemization. Such a disclosure shall include the payment due date after which interest charges or finance charges will be assessed, and it goes on and on and on. This is the closest we come to even dealing with contract law. Most families and a lot of funeral directors refer to the itemization of the funeral charges as a contract, a statement of goods and services sold. It's not a contract, but you are allowed to have your contractual language on that. After that line that says acknowledgement of receipt, we have no further control. We have no further jurisdiction. The only thing we would have is this caveat here saying that if you do have interest charges, that has to be on that itemization. Not really contractual language, but it has to be there. I'm talking faster, I can tell, because I know I'm running out of time. Next one is X, or actually, yeah, X, procuring or soliciting or attempting to procure or solicit funeral patronage through the use of door-to-door or telephone solicitation methods. So in other words, you're allowed to solicit business because you are a business, and you'd go out of business if you didn't solicit business, but you can't do it as door-to-door, knocking on the doors, or by random calling. So invariably, I will get at least twice a year, some funeral home will mail me a copy of the postcard that their competitor sent to everybody in the community, saying, come in and make pre-arrangements, or come in and talk to us. And they say, that's illegal. You're not allowed to solicit business. You have to solicit business, or you won't be in business long. You just can't do it this way. Actually got a complaint similar to this that came in anonymously recently. And I'm going to jump offline here just to point out that if you want to make a complaint about a funeral home, regardless of what it is, please do not do it anonymously. Actually, we got one first thing this morning. I got up at 5 o'clock this morning and checked my email. I got an email of a funeral home. I'm not sure where it is, but they were complaining about their competitor put something on Facebook that was not appropriate. So first of all, we're not the Facebook police. Second of all, if you don't put your name on it, I can't respond to you. If it is something egregious, the problem is if we ever want to bring charges against a funeral director for doing something egregious, we need to have the burden. We do have the burden of proof at a hearing. So in other words, first thing the administrative law judge is going to ask us is, how did this come to your attention? Oh, it came anonymously. Oh, so your number one witness is not available. So unless you want to put your name on something, you send it to us and we don't have any way to respond to you, chances are it's not going to go anywhere. We get this all the time. Somebody will send us an anonymous email saying, oh, there's unlicensed activity at Smith & Jones down the street, or the resident is not there all the time, something of that nature. Without any way to document that or back that up, we can't really go forward with that. Permitting a representative to be made, or describing any funeral firm or entity as a society, fund, trust, or in any other way which might indicate that such funeral firm as an entity is not for profit, unless they are not for profit. I'll say this right now, there's only one funeral firm in New York State that's a legitimate not for profit, and that actually took an act of the legislature, and this was years ago. But we have had startup firms, usually cremation businesses, that try to masquerade as a memorial society or something of that nature. We had, I'll just make up a name here. We've had something like Finger Lakes Funeral Society, or Finger Lakes Cremation Society, or something of that nature. We will turn those names down, those attempts to register that way, because that's a clear violation and leads to consumer confusion. Okay. So now we're up to the second half, and we're going to have to talk even faster. So there's 8 general, in addition to the 8 general business protections we just discussed, there are an additional 9 items particular to the interaction of the funeral provider with the customer. So counting down, I'm going to briefly discuss these using specific examples when we have time. So again, as you recognize, these are not in order. We started this presentation with A and D, now we're in B and F here. So exercising undue influence on a customer, misleading a customer, misrepresenting to a customer the sale of services or merchandise, and thereby taking unfair advantage of the customer. In other words, not being a good funeral director. You're exercising undue influence. These are open-ended. They're not well defined. This is where the administrative law judge would look at all the facts, listen to the witnesses, listen to the defense, and then come to their conclusions on whether it was undue influence or not. And F is harassing, abusing, intimidating, or otherwise threatening the customer. I've never had a complaint where a customer said, this funeral director threatened me if I don't buy the cherry casket, he was going to beat me up. We don't get that kind of thing. But we have had a case of harassment that went on. We had 4 complaints about a particular funeral director. And this was not about the funeral business per se, but it was really because all 4 of these complainants had been customers of this particular funeral director. Fortunately, before we ended up going to a statement of charges, he retired, sold the building, closed the business, and moved away. But it was sexual harassment is what we were dealing with. This funeral director would bury a man, and then a couple weeks later would start showing up at the widow's house with flowers and candy and asking if they're lonesome and they want to go out for dinner, and I just happen to be in the neighborhood and want to see how you're doing, to the point where one of them actually got an order of protection, if I recall. So again, this was harassment, harassing the customers. It wasn't about the funeral business. It was about trying to start a Lonely Hearts Club or something with widows. Eventually, he took the hint and decided to pack it up. Again, open-ended: abandoning, neglecting, abusing, or failing to treat with dignity and respect a dead human body entrusted to the licensee. These are not defined. What's abandoning? Again, we had this case where the body was left in the morgue for multiple weeks. The ALJ, the administrative law judge, says, yes, you abandoned the body, you neglected the body, you failed to treat it with dignity and respect. Ultimately, they ended up paying $28,000. Suggesting or implying in any manner that the customer's expressed concern about prices, inexpensive services, or merchandise, or desire to save money is improper or inappropriate. In other words, a lot of the regulatory language comes out of back in the early 80s when the FTC was putting together their rule. We put together our rule to try to, in an attempt to become exempt from the FTC, but it never worked out. All that motion started with a book back in the 60s called The American Way of Death by Jessica Mitford. And one of the accusations she made was that funeral homes routinely belittle the customer's choices if they are not spending enough. So if you loved mom, you'd get this casket, not that one. Why you're so worried about prices? You're only going to do this once. Your mom had a great life. Why don't you spend the money on her? So this is where this language comes from, is trying to address those concerns of the consumer public. Here we had a couple of questions during the break on this. Actually, we didn't really do a break. We just had a Q&A. Embalming or furnishing other services or merchandise without having first obtained from the customer explicit written or oral authorization. This is very similar to the one we just had a couple of slides ago, but again, you have to have authorization to embalm. And I actually just got a complaint in last week from a family where dad had come in 2018 and made pre-arrangements and did check out. He never funded it, so it wasn't binding, but they did check off embalming on the list. So the funeral home got the death call. They went out, picked up the body, they did the embalming, and the family showed up to make final arrangements, and they were like, "You didn't authorize that." So the only sad part about that is because it wasn't funded, he never signed the document. So I'm not sure which way we're going to be able to go on that one. Hopefully I'll get that settled before it has to go any further. This one is W, so we're moving along. Inducing the customer to consent to delay or otherwise change the desired day or time of the funeral by misstating facts or circumstances. With 2 caveats here. Resulting in an increase in charges for the funeral to the customer, or depriving the customer of their desire to have the funeral at a particular time when such a particular time has been expressed by the customer as a central element of the funeral. Okay, so depriving the customer of the desire to have it at a particular time. We did have a complaint that came in, ultimately was resolved with I think it was a full refund. Woman's husband died, went to the funeral home, said, he was very active in this particular church, so we have to have the services there. And it has to be Saturday because I have 2 sons that live out of state in different states, and they have to be able to fly back on Sunday because they both have important business to do on Monday. Okay. Funeral director goes in the office and makes a show of making phone calls or whatever is the way she put it. But he made a show of it. And came back out and said, no, this time of year, church is booked. There's 2 weddings, or I think there was maybe 1 wedding on Saturday. We can't do it on Saturday. It'll have to be on Monday. So her sons had to make business changes and travel changes. And they had the funeral on Monday, at which time at the end of the service, she came up to the minister and thanked him and said, I hope the wedding went off well on Saturday. And the minister said, what wedding? We didn't have any wedding. Well, why did the funeral director tell me you had a wedding? He said, oh, he was in a golf tournament Saturday. So, yeah, that was misrepresenting the circumstances and making the customer change their timing of the funeral. Letter Z, and again, these are not in order, so this is not the last slide. Requiring that a casket other than an unfinished wooden box be purchased for direct cremations, or failing to make an unfinished wooden box or alternative container available for cremations if direct cremations are arranged. So it sounds a little redundant from the earlier one. If you do have to have alternative containers, and by the way, I can't hammer this home enough, all your caskets and alternative containers are on the same casket price list. So you can't have 3 catalogs, one for direct cremation, one for cremation services, and one for burial. I've seen that in funeral homes. They all have to be on the same list. But one thing I want to point out here is if you offer direct cremations, that's the last line, if they're arranged. In other words, you are not required to offer direct cremations. I know several firms that don't offer that. I also know several firms that are just direct cremation businesses and they don't offer burials. So you don't have to offer every possible thing under the sun. Unfortunately, it still has to be on your itemization form, but you just put NA. So since I said there's 28, we ran out of letters with Z, so we're doing AA here. Conditioning the furnishing of any funeral merchandise or services to a person arranging a funeral upon the purchase of any other funeral merchandise or services, except as required by law or permitted by this part. Okay, I'm going to stop there because you can read the rest of it. This is what we call conditioning of a sale. And this was another one of Jessica Mitford's complaints that funeral directors back in the day would say, well, if you buy the cherry casket, you got to have the bronze burial vault, something of that nature. Now, the FTC oddly does allow packaging, and we don't because of this particular subparagraph in 77.12. It's conditioning of a sale if you have a package price. In other words, true packaging is when you take a list of items, and I see this on funeral homes, a traditional funeral service at our firm starts at $7,800, and then they list all this stuff out. That gives the consumer the belief that if they have to buy everything on that list to get that price. You can't do that in New York. You can do it in Pennsylvania. You can do it in Massachusetts. FTC allows it, but we don't allow it because of this particular subparagraph here. You cannot condition the purchase of any item on the purchase of any other, except for as permitted by this part. So having just said we don't allow package pricing, there are 4 places in which we do allow package pricing. And hopefully you're pretty familiar with those. Direct cremation is a package price. You take your transfer of remains, your basic arrangements, your transportation to the crematory, and return of the cremains from the crematory. In other words, you get 2 alternative vehicle charges. Add them all up. You can charge the full freight on that if you want, the full a la carte prices. But you can add them all up and then discount it down. Let's say it comes to $3,800 at your GPL. You can then put it on your GPL under direct cremation. You can mark it down as much as you want. You can make it $2,800 or $1,800. In other words, you can package those all together and discount it down. I've had a couple funeral directors, after talking about this, they'd say, oh, I never knew I could do that. In fact, I always wondered how my competition was getting away with such a low price for direct cremation. Again, there's 4 areas where you can do package pricing. It's direct cremation, direct burial, forwarding remains, and receiving remains. So that's what this is referring to when it says except required by law or permitted by this part being 77.12. And BB and BB1, this kind of got to jump around here a little bit. Charging additional fees for topical disinfection when embalming was selected or necessary because of other selections set out in item 1C of section 78.2. What is that talking about? We're on 77.12. 78.2 is talking about the itemization. So I'm going to jump ahead real quick. This is from 78.2. It's the format of a statement of goods and services. On your itemization, you have preparation of remains. First one is embalming. Of course, you have dressing and casketing, cosmetizing, whatever else. And you put that on there, and then you have to have this disclosure. If you select a funeral for which this firm requires embalming, there it is. Can you require embalming? This is the one place you can. You can't just because the body's been there too long, but you can require if you have the family selection open casket viewing. So that's why I wanted to point that out. I'll go back here again though. The other one I want to make sure I definitely talk about is BB2, charging additional fees for custodial care for a time period during which a charge was incurred for embalming or other preparation, or for visitation, or for funeral service. What's other preparation? Dressing and casketing, for example. So this question comes up a lot, and I'm going to give you a quick rule of thumb. Anytime you're charging the family for something that requires the deceased to be on the premises, you cannot also charge for custodial care. So this comes up all the time. Can I charge for refrigeration and custodial care? No, you're charged for one or the other. Because if you're charging for refrigeration, the body needs to be there. So you cannot charge for custodial care. Quick example, you get a death call Monday morning. You go and you do the transfer of remains. Okay, so then the body's required to be there for transfer of remains. Family comes in Tuesday morning and makes arrangements, and you go in and embalm the body. If you embalm the body on Tuesday, you can also charge for custodial care. Wednesday, you dress and casket the body. You're charging for dressing and casketing. The body has to be there for that. You can't charge for custodial care. Thursday's a visitation. Friday's a funeral. So you can have that body Monday through Friday and never charge for custodial care. Now, same scenario, death call on Monday, make arrangements on Monday, they drop off the clothing, you embalm, dress, and casket all on Monday. And Tuesday and Wednesday, you can charge custodial care. You're just holding that body. You're not charging for anything on those days. So anytime you're charging for anything that requires the body to be on the premises, you cannot also charge for custodial care. And that includes refrigeration. So we're up to, hopefully, the last section, merchandising misconduct. I got 7 minutes. I'm moving pretty fast here now. Okay, so the regulations also recognize that merchandise opens the consumer to possible sales pressure and creates an opportunity for a firm to take advantage. Of course, obviously the FTC this is where they started out, and New York State also takes a very strong stance. There's 7 items here. I got 7 minutes. We're cooking here. All right, we'll get through this. First one is, well, it's I and J. I has 2 parts. Charging for any item or merchandise not required by law, which is not authorized by the customer, which is not actually furnished. This is redundant. We had this earlier, under I forget which section it was under, but we have talked about this. Making a substitution for merchandise arranged or contracted for when such substitution is not authorized by the customer. Quickly here, the very first complaint I dealt with nearly 8 years ago was a complaint of a gentleman who was killed in a car accident in the Bronx. The family had to come in from Connecticut to make arrangements with the Office of the Chief Medical Examiner. They decided to just use a Bronx funeral home to do all the preparation, buy the casket, and was going to have the funeral director bring the deceased and casket to the church in Connecticut on the appointed time. They actually sent me video of this. Several complaints. First part was that the funeral director arrived an hour late, which is not good. I got the video of him getting out of the hearse wearing a polo shirt and shorts. They didn't like that either, but that's not a violation. But then they pulled the casket out of the hearse, and it was not the casket they selected. Simple phone call could have stopped him from getting a charge of misconduct. And this is one of my first referrals as well. The family had selected the particular casket because it was the deceased's favorite color. He showed up with a different casket and told them, the one you wanted, I couldn't get ordered in time. This is very similar to it and the same price. That's not why they ordered it. So simple phone call, he could have told them, couldn't do it. What do you want to do? Verbally disparaging to a customer the quality or appearance of merchandise or services which the licensee or funeral firm has advertised or offered for sale. Why would you do that? Why would you disparage the quality or appearance of the merchandise that you're offering for sale? We used to have a video that we showed at school about this undercover CNN expose about funeral homes, and there was one in which the hidden camera person was showing some merchandise. She picked a 20 gauge non-sealer, and the funeral director tapped on it and said, "Oh, that's one step above a Maxwell House coffee can." And I remember seeing this video and thinking, why would you even offer that if you thought it was not worth selling? Charging for any item of merchandise which is not required by law and which is not actually furnished. Again, some of this is sounding a lot of, like there's a lot of redundancy built into the regulations. And again, substitution of merchandise when such substitution is not authorized. And that's something we just talked about. Verbally disparaging to a customer the quality or appearance of merchandise or services which the licensee or funeral firm has advertised or offered to sell. And again, this is just like the guy was talking about his casket being a coffee can. I think we're at the end now. Failing to display, this was common. I see this in a lot of funeral homes. Failing to display the less expensive items of merchandise advertised in the same manner as the more expensive. I see these double racks in selection rooms. The lower casket is closed and the upper casket is tilted forward with a lid open and the light shining in it. Technically, that is a violation here under N. You have to show them the exact same light. You can't emphasize one over the other. And then I believe this might be a little very close to the end. Making false, misleading, or unsubstantiated claims directly or by implication as to the benefits or quality of funeral merchandise. A couple of caveats. That this merchandise will delay the natural decomposition, or that protect the features that will protect the body from the grave site. And then some of this is pretty straightforward. It's just conspicuously and legibly displaying the actual retail price. Even if you're using an electronic catalog now, I think that's fairly common. I've seen a lot of funeral homes that use either a TV display to show their merchandise or a tablet. So same thing applies. You have to legibly display the retail price, and it has to all be the same way on every one. Showing the price that is not the actual price. I know it's $258. We're cutting down here. Oh, we made it. All right. It's funny because as many times as I've done this presentation, sometimes I end up 20 minutes early. Sometimes I go over. This one we cut it right to the last minute. So you want to stay on and hear any more questions? I'll answer questions as long as they keep coming. If that's if we're good at your end, I think we're done here.
Thank you, Tom. Yeah, we do have some questions, so I'll go over those. And then whoever wants to stay on can stay on. Okay, what if we receive a call from the police to make a removal of someone whose family cannot be contacted?
If you receive a call that someone's family cannot be contacted? In other words,
so
no
you're
family
making
at
the
all?
removal based on when the police are calling you to make the removal, not the family.
Okay, so the police are calling you and they can't locate the family? If I'm understanding that right, there's no family involved at all? At that point,
Correct.
I would contact the county. Because family can only show up later. I had that happen to me once. The county took charge and authorized the burial. And 3 months later, your family showed up and wanted to know if we'd gotten a flag for their loved one who was a military veteran. It's like, where were you 3 months ago? Yeah, I would defer to the county.
Okay, if a hospice nurse or any employee of an institution calls us advising us of the death, but the family has not called us directly, is that considered solicitation? Because we would have to reach out to the family before we could effect the transfer.
Well, I mean, each funeral home has their own policies. And the last place that I worked, our policy was, even if they have a signed face sheet, we called the family before we started the car, regardless of day or night. And I always asked the nursing home, generally it was the nursing home, there was 2 in our community that were pretty prominent. I'd always ask them, have you contacted the family? And if they said no, I'll say, what number do you have? And I would start calling, and I'd let the nursing home know I'm not coming until I get authorization. But that's, each firm has their own policy. Again, if the nursing home has a signed face sheet specifying to contact you, we would consider that written approval.
Okay, I have a contract with the county to provide indigent burials. The county pays less than what my GPL has for an immediate cremation. Is the itemization filled out with the amount the county pays? I've always thought the itemization had to match your GPL, but could give whatever discount you wanted on the final bill.
Yeah, there's nothing specific in the regulations about that. I know there's a couple of ways that it's handled. You can have, the regulation does allow you to go into, I think it's 78 under GPLs, or is it 79? It does say you can have a separate GPL for a governmental or not-for-profit agency that you want to contract with. So in other words, you have a memorial society in your town, or you do have a contract with the county, you can have a separate GPL for that. I've seen other people just put their GPL prices on there, and as you say, just do the discount at the end, DSS discount. When I was doing it in the county I worked in, they were very generous. So I would put their prices on the itemization, and I would make a second itemization with our prices, and always gave them both to the family just to let them know this is how much money you saved, because if they got too demanding, I actually did this once. I told the family, well, you're welcome to pay this directly, and you can do whatever you want. Right now I'm working for the county. So yeah, because it seemed like some of those families were the most demanding. But that's my experience. So there's nothing in the regulations that say how you have to do that, as long as you document everything. And if you have a contract, might not be a bad idea to throw that in the file with that itemization if you ever get called to surrender documents. So that way, at least we have some understanding of why this particular call was so much less than the others.
Can a funeral home charge to remove a pacemaker if the charge appears on the GPL?
Yeah, always you're entitled to get paid for anything you do, and I have seen that. I've seen some pretty outrageous charges for that, because it's not our requirement that the pacemaker be removed. That's the Division of Cemeteries requirement. So this is a service that you're offering, and the family has to be aware of that. You say, look, did Dad have a pacemaker? Yes, he did. Well, there is a separate charge for, we have to surgically remove that. I always use the term surgically. It sounds more impressive, but I'd always tell them we have to surgically remove the pacemaker.
If a customer is price shopping and tells funeral home B that funeral home A is going to do a cremation for X amount of dollars, and funeral home B says we will do it for cheaper amount, the amount that's not listed on their GPL, is that allowed by funeral home B?
I would refer you to our website where the letter that went out in might have been 2019 about price match guarantees. When you start playing Let's Make a Deal, you're completely defeated the purpose of a GPL. Now you're allowed to give discounts on occasion, family loyalty, $500 off, or, or if you stayed at, all veterans get $500, whatever. But when you start playing Let's Make a Deal, first of all, you're opening yourself up to, everybody's in total confusion about what you actually charge for anything. And you can get into bidding wars with families. I don't know why you would want to open yourself up to that, but we prohibit the price match guarantee. We had a few funeral homes that were advertising, just like when you walk into Lowe's or Home Depot, price match guarantee. Yeah, bring us any GPO from any of our competitors and we'll match it. Yeah, it's like a car dealer. I mean, so we did send out a letter. It was sent to everybody. It's posted on our website. The legal reasoning behind that letter and why we do not allow this price match guarantee thing.
Do you have any last minute recommendations to anyone who happens to be listening who's taking the law exam tomorrow?
About the law exam tomorrow, come early, because I think we had 45 candidates originally. There's been a few that have did not get their stuff in on time or did not respond. So I think we have 41 candidates. Parking at the concourse has always been an issue. We never know what's going on. One time we had the exam the same day they were doing all the attorneys in New York were being sworn into the bar at the same place. So go early. Don't be afraid to go early. There's several places on the concourse if you want to get breakfast there. But parking, if you want to get parking, and I myself on occasion have ended up parking several blocks away and having to walk with all the materials. But yeah, that's my biggest recommendation. Get there early. Don't sweat it. It's 50 questions. You got 2 hours. It's more than enough time to answer the questions. And whoever it is out there that's taking the exam tomorrow, I wish you luck.
If an alternative container is provided by the funeral home and is included for a direct cremation, does it have to be included on the casket price list?
Yes, yes. Alternative containers are on the casket price list. Again, I had a firm that was offering 3 different catalogs. If you came in and you said you wanted direct cremation, they had a catalog with a plain cardboard box, and the wood grain cardboard box, and the wood grain cardboard box with a pillow, and this is their direct cremation catalog. You can't do that. You have to show them your entire selection. And also you have to display them. If you have, if you're doing it with a catalog, you can put them all in the same catalog. You're required, even if it's electronic. So yes, you do have to have them all together. And I had a family come in one time. For direct cremation, they saw the cardboard box and they were like, "No, I don't think so." By the time they walked out, they spent $600 on an actual casket. The bare minimum wooden casket, but they decided that's what they wanted. So it may not be a bad idea in the long run.
On a pre-arrangement, if the customer chose to be cremated, has passed away, and now there is no next of kin that is able to be located or even alive for that matter, the crematories are stating that the most up-to-date 3-pager, the authorization for cremation disposition, needs to be completed, and the one previously completed on the pre-arrangement is outdated. The crematory refuses to allow the cremation without the latest 3-pager. What are the options for the funeral director to pursue for getting the latest 3-pager completed in this circumstance?
I'm sorry, the latest, what are they looking for? The latest what?
So the way I'm reading it is that if someone signs the authorization for cremation disposition upon doing a pre-arrangement.
Yeah, you can't do that.
Right.
Yeah, I get that.
So, yeah, the person that just emailed us and the cremation authorization does have to be after the death.
So I get, if I'm understanding, somebody made pre-arrangements for themselves for direct cremation, and then when they died, there was nobody else around to actually come in and make at-need arrangements, if I'm understanding this correctly. Again, 4201 says if their wishes are known, you got to follow the wishes. So who's going to sign the cremation authorization? You know, yeah, good question. You can't sign your own cremation authorization. We've been through that before, where funeral directors were having people sign their own cremation authorization, and it's got to be, the person under 4201. So I'd go down that list. If there's nobody around, the last one on the list is the county, and you can go to the county attorney and say, "Here's the pre-need. It's all paid for. I just need somebody to sign for this." And I mean, there'd be no questions asked. I mean, who's going to ask questions if there's no family? And his wishes are known, everything's paid for. I don't see why the county would balk at that, but every county is different, I guess.
The Green Burial Council requires members to offer a green burial package. There are firms in New York State who are members of the Green Burial Council. How is this possible if that is not a package option?
Yeah, I haven't seen that specifically. It's interesting. I haven't heard about that, a green burial package. There's sometimes they call it a package where you get a discount if you do this. But again, if the Green Burial Council is a not-for-profit entity, they can have a separate GPL. As long as they have a contract with the funeral home that you handle our clients and our members at this price, I doubt the Green Burial Council, the national one, does that with individual funeral homes. But there's a difference between a package and a bundle. Package is where you take 10 items off the GPL, add them all up, and then discount the total. A bundle is where you just list them all. And I see a lot of funeral homes doing these bundles on their websites, which is confusing to the consumer because they think it's a package deal. So yeah, I might take a look at that Green Burial Council, see what. It's been a while since I've had any contact with them. Probably been a few years, probably before COVID. So I haven't been really up to date with what they're doing. But yeah, if it's a true package deal, I'd love to see where that's happening. If anybody out there who's ever asked that question, if you have any documentation like that, we're not going to put you on the spot or, put your name out in the public. You want to email us what you got on that? I'd love to take a look at that.
Why are cemeteries permitted to package items such as a new grave and new grave liner? Websites are taking our casket sales, and now cemeteries are taking our vault sales.
Well, we don't regulate the cemeteries. That would be a question for Lewis and company. There was some controversy before, I'm talking a few years ago, about cemeteries selling grave vaults, but some of them are built in. They call them lawn crypts. And that was under the FTC. If you're offering both goods and services, you're supposed to be registered as a funeral home. But somehow they got around that. There was some kind of a ruling that that's part of the cemetery equipment, I guess. Yeah, so again, that'd be a question more for Lewis and his company.
Regarding the customer's designation of intentions, if I mail cremains via USPS Express with the receipt and tracking, and the family will not sign the receipt section of this form, is this USPS receipt acceptable?
Yeah, I mean, once the final disposition occurred, we don't have any say about how or where the cremains get sent. So that would be an issue. I mean, if I'm understanding the question right, the family didn't refuse to sign for the cremains?
Yes.
Okay, and then where'd they go? They go back to the funeral home or back to the crematory?
That's a good question. Maybe you can maybe this person can follow up with more information.
Depends on who mailed them. I mean, there are some crematories that will mail them, and you know, if they're the ones that mailed them, they're the ones that are going to get them back. But again, you got to see what your customer's designation of intention says too.
If a body is embalmed or refrigerated for a month, can you charge for custodial care?
If the body hasn't been embalmed and what?
Embalmed or refrigerated, can you charge for custodial care?
You cannot charge for custodial care if you're also charging for refrigeration, because the body has to be there to be charged for refrigeration. So you can't charge custodial care as well. As far as embalming, you can't charge for custodial care on the day that the body was embalmed. But if you have a body, you embalm it on Monday and the family's not coming back till next Wednesday, you can charge custodial care the rest of the time.
Okay. Sure you hear this question every biennium, but I'm going to ask it again, Tom. Will our new registration and pocket cards finally have our photo on them?
I'm sorry, can you repeat that?
The new pocket cards that they will be getting, will it have their photo on them?
They will not at this time. We are still working with the DMV, and we always come back to a glitch with, we have, last report, we have nearly 400 funeral directors that actually live out of state and don't have a New York State driver's license. Plus, we're in negotiation with the Bureau of Accounts Management to figure out how to pay for those. There has been progress. I've got 8 years of progress. I've got a actual mock-up of what the card will look like. It'll be a hard plastic card with your photograph and Department of Health on it. The one I got is for somebody named Maria Motorist with her picture. But you know, it's, again, we got a very small staff, and we chop away at the edges of this when we can. I hope before I retire that the picture IDs will be come to fruition.
This question pertains to using a virtual casket showroom. Is it acceptable to use a printout of the virtual showroom as your casket price list?
Sure, yeah. I mean, there are a lot of little funeral homes back in the day that didn't have a space for a showroom, and they just had a catalog. And you know, you flip through the pages with the family, and they would choose what they needed. Yeah, but again, you know, the casket price list thing applies. If you're using a catalog, all the prices have to be the same size. You have to list, you know, what the regulations require. You know, the model, the material, the supplier, you know, the price. You know.
I'm not sure if this is your department or Lewis's, but whose responsibility is it to have the body delivery receipts? The funeral home or the cemetery? Or yes, the cemetery.
Well, you know, technically the cemetery is supposed to provide that, and very few of them do. That's been my experience, it's kind of weird because the body delivery receipt came out of the public health law on the funeral directing side, and it didn't come through the Division of Cemeteries. And this all dates back to the body scandal where they were chopping up bodies and selling the parts and, you know, harvesting tissue and all that back. I don't know, it's got to be 25, 30 years ago now. And that's where that regulation came out of. As far as having a body delivery receipt, I don't even know who would enforce that at this point. I think it's part of ours, but it's not on that list in 78.1 D2 about the list of documents you need. So, you know, it's been a long time since I've had any questions about that. I know some crematories automatically do it, but I know most of the places I've ever been with a final disposition, I've had to fill it out myself and bring it and have them sign it.
Okay, we use a crematory in Connecticut. as a New York funeral home, do we need to send a license, even though in Connecticut a license is not required?
No, as long as you have that burial transit permit and you're going out of state, we have no jurisdiction over Connecticut. So licensed funeral director, release the body to the transporter, you're good to go.
Okay. With regards to the survey, where does the Bureau see the licensure requirements going? What does the Bureau forecast or predict to lose to retirements, relocations, and unfortunately deaths in the next 10 years as far as licensees?
Wow, that's a tough one. I did a 20-year comparison there a while back, and the number of funeral directors, and I had the figures with me at the convention last year. Number of funeral directors dropped like 2,500. Just anecdotally, I can tell you that I've got at least a dozen re-registration applications returned to me with deceased written across them so far. I've got another dozen that just wrote "make me passive" sent back. I was talking with Matt Doran yesterday about this trend, and I said, I think we're going to lose 100 funeral directors this year. Fortunately, we have been licensing people pretty steadily. What the attrition rate is on that is, I couldn't even tell you. It amazes me the number of people that get licensed and the next biennium they don't bother to reapply or re-register. So it's hard to say. I think we can do a report of the number of registered funeral directors at the end of the year. Right now, if I do the report, it's only showing about 400 because that's how many applications we've processed. But yeah, I'm kind of anxious to see what that looks like. And I'll be honest with you, when I go out and do these presentations in public, I look around the room and probably only 20% of the people there are younger than me, and I'm not young. I used to be.
Does the GPL have to be presented at the beginning of an arrangement or not until prices are brought up?
It's anytime any question is asked about funeral goods or services, and that's an FTC rule too. So, you know, I know in New York City they got a separate rule. You have to have it within 15 feet of the door and things like that. But yeah, anytime they ask any question about, and technically, if you're calling hours and somebody says, "Hey, that's a nice funeral. What would something like that go for?" And I'm a GPL. You know, better safe than sorry. The FTC did a sweep through, I think it was Long Island, within the last 2 years, randomly knocking on funeral home doors and asking for GPLs, and they handed out a lot of fines. So better safe than sorry. Oh, by the way, the FTC is still debating about whether or not to require you to post your general price list on your website if you have a website. You're not required to have a website. We don't require it. We don't police it. But if you do have a GPL on your website, make sure it's up to date. Just got another one of those complaints from one funeral home complaining about another funeral home. They changed their GPL last January, didn't change it on their website. It's like, well, did you tell them that? No, they didn't. Yeah, so yeah, anytime they ask any question about anything about goods and services, you are required to pass out a GPL.
Is there a problem with a funeral home supplying a reward for pushing families towards a particular funeral home?
Say that again, because I'm not entirely clear on what that was.
I'm not really clear on the actual what a reward would be, but is there a problem with a funeral home supplying a reward for pushing families towards a particular funeral home?
Oh, a reward.
In my mind, I'm thinking like thanks, where you get a free crock pot if you open accounts.
If you are paying a third party to push calls your way, like for example, you know, paying people at the emergency room or, you know, at the local nursing home, that is clearly illegal. I remember years ago when I was teaching at Simmons, there was a local funeral director that got brought up on charges by Debbie Arecki just for sending pizzas to the local emergency room with his business card stapled to the box on Friday night. You cannot do third-party solicitation like that. You cannot pay a premium or anything of that nature. I don't remember the chapter and verse of the regulation, but it's pretty clear.
Okay, only 2 more questions. We're almost there. I know of a funeral home that has custodial care listed on their GPL that is included in their direct cremation. Is that legal?
Direct cremation is direct cremation. That's a separate price. That's one of the things we had a hearing about with this one individual that I said was marking up the crematory charges. He was advertising all over his area of $9.95 direct cremation. Everybody was calling him up because it looked like a great price. But when we did our investigation, we pulled like, I think it was 15 or 20 random itemizations for him, and he was charging custodial care. He was charging topical disinfection, on and on. And direct cremation is direct cremation. So unless the family's aware of it and they request an additional charge, and again, this topical disinfection was something he told the families, this is for my protection and my staff's protection. You can't do that unless they request that. And as far as custodial care, I've actually had some funeral directors tell me as soon as they claim the case on EDRS or e-vital in New York City, I start charging right away because I'm responsible. No, if you don't have physical custody of that body, if in this example, this particular individual that went to hearing, you'd get a death call on a Friday night. The crematory that he was using in Pennsylvania wasn't open till Monday. He would rush out and get the body from the morgue just so he could claim custodial care. You have to inform the family ahead of time. So they have to be able, everything has to be declinable from the family. So the only thing that normally would be allowed to be an increase on the direct cremation charge would be mileage.
Okay. And the last one is, do New York City and out-of-state cemeteries need to provide a body receipt even though they're not regulated by New York State?
If they're out of state, they don't have to provide that. That's only a New York State requirement. They may, I mean, I don't know what Connecticut does or what New Jersey does, but if they offer kind of receipts, certainly take it and put it in the file, but we can't compel them to do that.
Okay. Well, Tom, thank you so much. And I will say that we've gotten a lot of comments through the questions, just saying thank you so much. This is great to have you so available and cooperative and collaborated with us and with the funeral directors of New York State, and being so open with and available. So I just want to pass that along. We really appreciate that.
I look forward to having an opportunity to go one-on-one with the funeral directors out there. Since COVID, it's been a lot more of this kind of interaction, but hey, any interaction is good interaction. So I appreciate you.
Great. Well, thank you so much to everyone for joining us, and Tom, thank you. I know it went over 2.5 hours, which is a very long time to talk, but we really appreciate it.
Hey, I used to do 4-hour classes at Simmons, so. All right, thank you.
Thank you so much again, and have a great afternoon, everyone.